in the Circuit Court of Cole County, 19th Judicial Circuit, State of Missouri. Missouri Republican State Committee. Plaintiff v. Case number 24AC-CC02151, Secretary of State, et al. Defendants. McClanahan answer. Defendant Darrell McClanahan responds as follows to the plaintiff's petition. 1. Defendant McClanahan has no personal knowledge regarding this allegation, he therefore denies the allegation. 2. Admitted. 3. Admitted. 4. This paragraph alleges legal statements and conclusions to which no response is required. To the extent a response may be required, McClanahan denies the allegations of this paragraph. 10. I. This paragraph alleges legal statements and conclusions to which no response is required. To the extent a response may be required, McClanahan denies the allegations of this paragraph. This paragraph alleges legal statements and conclusions to which no response is required. To the extent a response may be required, McClanahan denies the allegations of this paragraph. This paragraph alleges legal statements and conclusions to which no response is required. To the extent a response may be required, McClanahan denies the allegations of this paragraph. Admitted. Admitted that the committee had a table at which 6 persons were accepting filing fees and issuing receipts on behalf of the committee. Defendant McClanahan has no personal knowledge regarding this allegation, he therefore denies the allegation and, further, contends that it is irrelevant to the legal issue the plaintiff has presented to the court. Defendant McClanahan has no personal knowledge regarding this allegation, he therefore denies the allegation and, further, contends that it is irrelevant to the legal issue the plaintiff has presented to the court. 12. 13. 14. 15. 16. 17. Denied. Several months before this year's window opened for candidate filing, the Republican Association of Central Committees of MO circulated a document detailing ways that Missouri Republicans could lawfully vet potential candidates prior to accepting their filing fees and explaining the party's right to refuse a filing fee offered by a prospective candidate for office. A copy of this document is attached as Defendant McClanahan's Exhibit A. Defendant McClanahan denies that he is either racist or anti-Semitic. Admitted, but McClanahan contends that this allegation is irrelevant to the legal issue the plaintiff has presented to the court. Admitted, but McClanahan contends that this allegation is irrelevant to the legal issue the plaintiff has presented to the court. Admitted that McClanahan filed the case referenced in this paragraph, but McClanahan denies the plaintiff's statements that are not direct quotes from the relevant document and, further, contends that neither the case he filed nor any statements therein are irrelevant to the legal issue the plaintiff has presented to the court. Defendant McClanahan has no personal knowledge regarding this allegation, he therefore denies the allegation and, further, contends that it is irrelevant to the legal issue the plaintiff has presented to the court. 18. 19. 20. 21. 22, 23, 24. 25, 26. Admitted that the committee sent him a letter, but he contends that it is irrelevant to the legal issue the plaintiff has presented to the court. Admitted that McClanahan responded to the committee's letter, but he contends that it is irrelevant to the legal issue the plaintiff has presented to the court. Admitted that the committee attempted to return McClanahan's filing fee, McClanahan denies that he accepted this attempt. Defendant McClanahan has no personal knowledge regarding this allegation, he therefore denies the allegation. Denied. Denied. This paragraph alleges legal statements and conclusions to which no response is required. To the extent a response may be required, McClanahan denies the allegations of this paragraph. Denied. Denied. Affirmative defenses. The claims the plaintiff has presented in this case are identical to those this court heard and rejected in 36 inches Democratic House District Committee v. Boyd, case number 24AC-CC00442. A true and accurate copy of this court's final judgment in that case is attached as McClanahan's Exhibit B. The petition does not identify any specific law or discretionary governmental action that it alleges to violate the First or 14th Amendments. The petition does not allege that any specific provision of Missouri law is unconstitutional, either facially or as applied. Missouri courts are only allowed to award relief that has been sought in the parties' pleadings, meaning the court has no authority to rule on parts of Missouri election law that the plaintiff failed to identify in its petition. The plaintiff failed to allege that the Secretary of State has any discretion to remove from the ballot the name of a candidate who complied with state law in submitting their filing fee and declaration of candidacy. Even if the plaintiff had included such an allegation, Vowell v. Candor, 451 SW3D 267 Mo. App. W. D. 2014 firmly established that under Missouri law the Secretary of State has no authority to refuse to certify for a primary ballot the name of a candidate who has filed properly executed legal documents with his office. 10. 11. 12. Section 115.387 imposes upon the Secretary of State the ministerial task of certifying the names and addresses of candidates for the ballot. ID. At 274. The Secretary of State's sole duty under this provision is to certify that filers have timely filed their declaration of candidacy with all the information required, and to treat all persons filing properly executed legal documents with his office equally. ID. At 275. The appellate court's ruling in Vowell is binding on this court and it precludes the relief the plaintiff has requested. The court's consideration of this case should be further guided by its ruling in Boyd, that where, as here, a political party accepts a candidate's filing fee it waives the ability to assert First or 14th Amendment rights not to associate with that candidate for the purposes of the relevant election. McClanahan was known to the Republican Party because he had previously been a candidate for U.S. Senator on the August 2, 2022 Republican primary election ballot. The committee accepted the filing fee McClanahan offered on February 27, 2024, when he indicated his intent to seek the Republican Party's nomination for governor. 13. By accepting McClanahan's filing fee on February 27, 2024, the committee relinquished any right it otherwise might have asserted under the First and 14th Amendments to prevent McClanahan from appearing on the Republican ballot for the August 6, 2024 primary election. Boyd at 10. 14. Furthermore, the committee has come to this court with unclean hands because its own conduct is the source, or part of the source, of the equitable claim it has presented. 15. But for the committee's choice to accept McClanahan's filing fee and thus create the now challenged association, there would not be a controversy. Boyd at 10 to 11. 16. In light of the committee's own prior associative decision regarding McClanahan, the committee cannot demonstrate any substantial constitutional injury that might justify the relief it has requested. Wherefore, Defendant McClanahan respectfully asks the court to render judgment in his favor and against the plaintiff, to award him reasonable attorney fees. D. T. Re. L. Nahan IT, Pro Se. Certificate of Service. I hereby certify that on this 6th day of May 2024 that a copy of this motion was sent via U.S. mail and email to Lowell D. Pearson No. 46217, Thurman Law Firm and Derek R. Good No. 50300, Counsel for Missouri Republican State Committee. Respectfully. A5 Darrell McCl5 Anahan D. Errol 4 Magav at gmail.com 417-388-9595. 24346 S2425 Road. Milo, Mo 64767. In the Circuit Court of Cole County 19th